David had been keeping lab notebooks since graduate school, bound composition books, dated and signed on every page, with detailed records of every experiment, every failed attempt, every breakthrough. When he joined the company in 2016, he kept the practice 12 notebooks over 6 years, all stored at home after scanned copies were uploaded to a personal cloud. When he saw the patent application in a trade publication in March 2022, his name wasn't on it. The technology was his. The invention date they listed was 2021. His notebook started in 2017. The patent in question covered a method for reducing energy loss in a specific type of industrial sensor, a problem David had been working on since his master's thesis. The company had hired him specifically because of that work. His employment contract included a standard IP assignment clause, assigning all work-related inventions to the company. What the clause did not cover, and what David's attorney identified immediately, was inventions David had substantially developed before his employment began.
The lab notebooks were the core of the case. They documented the theoretical framework in 2017, the initial experimental results in 2018, 2 failed iterations in 2019, and a working prototype concept in early 2020, all before David had brought the work into the company environment. The company's patent listed the invention date as Q3 2021, which was when David had implemented the technology in a company project. But implementing a previously developed invention is not the same as inventing it.
David's attorney filed a derivation proceeding with the U.S. Patent and Trademark Office, a formal process for challenging who invented what and when. The proceeding required submitting David's notebooks, his graduate thesis, conference papers, and email records showing when he had first discussed the technology. The USPTO examiner found the notebooks credible and contemporaneous. The company's attorneys spent 4 months trying to establish that David's pre-employment work was insufficiently developed to constitute prior invention. They did not succeed.
The settlement included joint inventorship status on the patent, David's name added alongside the company's engineers, and a lump sum payment for back royalties calculated from the filing date. The payment was $84,000. David also negotiated a license arrangement for any future commercialization of the technology outside the company's core business. The employment relationship ended by mutual agreement. David filed his own continuation patent on a related method 3 months later.
The lab notebooks worked because they were authentic. David hadn't kept them in anticipation of this dispute. He had kept them because that was how he worked. The witnesses who corroborated the timeline, his thesis advisor, a colleague from his pre-employment research group, weren't recruited for the case. They existed because the work had existed. The evidence was credible because the underlying work had been real.
The USPTO derivation proceeding costs approximately $400 to file. David's total attorney fees were $31,000. His total recovery was $84,000 plus the license arrangement. The lab notebooks that made the difference cost $8.40 all each at a university bookstore. If you build something, document it. Date everything. Sign every page. Keep the notebooks at home. Subscribe.